Today we're talking now about how do you get more money in your personal injury case. That's what we always are striving for. We want to get you absolutely the most money that you can get for your particular case. As a caution, I'm going to say every case is unique and different. Speak to your lawyer about your particular case, the facts of your case, and what you can do in your particular case to improve the success. But today what I'll share with you are some of the observations I've made over the years, some common factors that contribute to getting more money in your injury case. Number one, you've heard me say this on other videos, medical support, medical records. The medical healthcare team are the strongest component in most cases for identifying the injury, the prognosis, the impairment, the impact it's having on you. It's essentially the predicate, it's the foundation upon which everything else rests. Doesn't matter how hurt a person is, without that foundation, without the support of healthcare and medical professionals, you're going to get less money, period. You stop going to the doctor, stop reporting your symptoms, or the healthcare team doesn't support you in some way, your case is going to get less money. Number one, healthcare, critically important. As long as you're having injuries and symptoms, continue to treat, follow with your healthcare team, report your symptoms, talk to your doctor, talk to your healthcare team, and get recommendations for treatment. Speak to your lawyer about suggestions for improving your case if that's where you think you need improvement on the medical side. Don't downplay your injuries. I had a discussion actually recently with a new client about that. Very optimistic person, extremely serious injuries. He's been hospitalized for nearly 2 months, but extremely positive and very proud of any gains he makes, any progress he makes. But I explained to him, careful how you describe it, because they're going to write down he's feeling 80% better today. Maybe it was for 5 minutes. The insurance company will look for anything to hang its hat on, and they will scour those medical records. And in the future, when you're at a deposition or your lawyer's advocating for you, sure enough, they will pull up that record. Well, 2 months after the accident, the nurse wrote down, today he's feeling 80% better. So the context is missing. So be careful. Everything you say to your healthcare team is likely going to be recorded. When you're dealing with your healthcare team, deal with healthcare. Tell them what's going on in plain language. If something hurts, say it hurts. Use the word hurts. Pain. Very plain language. As opposed to, it's uncomfortable. It bothers me. You're giving it a level. But what is it? Whether it's sore or uncomfortable or bothersome, get to the root of it. Does that mean it hurts? Does that mean you have limited range of motion? What does it actually mean? And just use the plain language. Don't downplay your symptoms. The insurance company doesn't need your help to downplay symptoms. Just stick to the facts. You're going to get more money. Another important point that kind of ties in with what you tell your doctors is statements. So if an insurance adjuster or an insurance representative or an investigator calls you up and tells you they want to talk about settling your case and they need a statement and they want to interview you, that should be a red flag. Because again, what you say early on, they will go to time and time again as your statement, and they're professionals. They know how to get the right admissions out of you that may appear harmless at the time, but later down the road come back and are used against you. Red flag, insurance adjusters trying to speak to you or take statements. That's the time to make sure you get a lawyer on your side and get informed. And if you are going to give that statement, at least you have the benefit of an attorney sitting by your side. Another way I would say is to say no. You got to say no. You have to learn, you and your lawyer need to learn how to say no when the offer is not enough. If your lawyer has confidence in their abilities, their ability to advocate, their ability to build a case, to present a case, their ability to evaluate a case, they're going to be confident enough to say no. It sounds obvious, but in my experience, a lot of lawyers reduce their expectations of a case, second guess themselves. I've seen it with young lawyers I've seen it with old lawyers. They come out first thinking their case is worth X. This is what it's worth. They can justify it to you. And then they get in the weeds of negotiation or the weeds of litigation, and suddenly they're buying into the defense argument, and they're starting to reduce their own outlook on the case. So you have to have a lawyer that's confident enough to say no, and to help you feel confident enough to say no when it's not enough. In our experience, saying no almost always, not always, but almost always results in more money. Okay, a willingness to say no when it's a lowball offer. I would also say along those lines is if you have a case, every case is different. So this might not apply to a very minor case. But if it's a significant enough case with merit, having the confidence and willingness, the confidence in your lawyer to carry on, to go to the next step, to keep pushing the case closer to trial. In our experience, that also maximizes the value of a personal injury claim. I'll give you an example. Very recently, the insurance company offered extremely modest amounts of money. And we're talking in the teens of thousands, so less than $20,000 for a case that we believed was a six-figure case, and just kept saying no. And thankfully, we had a client that trusted us, that had confidence in our ability, and we remained confident that ultimately they're bluffing, they're lowballing, and so they would increase the offer a little bit at a time as we got closer to the courthouse. We went to a mediation. Again, a willingness to say no at a mediation, really important in the right case, okay? Because they'll put money in front of you at a mediation. But if you know it's not enough, if your lawyer knows it's not enough, you have to be able to get up and walk out. And that's what we did. And we got it prepared and ready for trial. But as expected, once the insurance company realized we were not walking away, we were not willing to accept a lowball offer, they made a very significant offer, at least 20 times more than what they had initially offered on this case. At least, probably more than that. So, what changed? The case didn't really change. Got stronger with time because we kept marching towards the courthouse. The fundamentals of the case remained the same. The only difference was we were willing to take it the distance. And so that's important too. If you've got the right case, you want to have a lawyer that's willing to take it the distance for you to maximize your recovery. So another way to get more money for your injury case is to develop the various damages, the heads of damages. You've heard me on other videos, but there are different categories. It's not enough to say, oh, I'm hurt, give me this money. You have to categorize it. You have to break it down into what the law allows you to recover. That's what the insurance company cares about. If you were stepping into a courtroom and the jury had to decide categorically where to award you the money, they need a category. They need a basket to put it in. Opening up as many of those baskets as possible will generally increase the amount of money you get for your personal injury claim. If you've watched any other videos, you've probably heard me describe them before, so I won't get into too much detail. But there's the non-economic, non-pecuniary loss, generally understood as pain and suffering. Pain and suffering, loss of enjoyment of life. It's what we would refer to as a non-pecuniary general damages component. And all that really means is you can't do math in the traditional sense to figure out what's been lost. It's very fact-specific. It's about developing the story of the individual and what's been lost to them. The enjoyment of life, the recreation, the relationships, the dignity, all those intangibles, so to speak. But then there are also the economic losses, so you want to open up those baskets because otherwise you're leaving a lot of money behind. Is there an income loss? Is there a risk of future income loss? Is there a loss of competitive advantage? Further promotions, advancements, career changes, etc., longevity to your career or your job. Certainly want to explore healthcare expenses. So not just the past healthcare expenses, but the future expenses related to maintaining your home. All of these things that now you may have to purchase or hire others to do. And that opens up baskets, and if presented right, It creates risk to the insurance company. With risk comes more money, generally. The other part is fault. If you don't have a strong case that it's the defendant's fault, doesn't matter how good your damages might be or the monetary value of the harms and losses, you don't get it because you must establish fault. That's fundamental. Insurance companies know this, so they're fighting you on both grounds. They're fighting you on what your case is worth, but also fighting you on the elements or the percentage of fault. In many jurisdictions, the insurance company, if they can show that it wasn't completely the fault of their insured, the defendant, then your damages get reduced. So if they were 60% at fault, you can only recover 60%. In some jurisdictions, there are ways where they can eliminate all of their exposure by showing that the injured party was contributory negligent and certain thresholds or what that means. So 51%, for instance, in many jurisdictions would preclude a person and their right to recover any money at all. So fault is important. You need a lawyer that is going to have the resources and the resilience to prove that it's the other party's fault. You want more money for your personal injury case? Avoid posting self-harming information and videos and posts on social media. Social media can destroy a case. It can undermine your medical records. It can undermine what you've said in deposition under oath. It can undermine statements. If you're reporting things to your doctors, don't be doing something in social media that is inconsistent with that. Try to limit your posting as much as possible on social media because the insurance companies are always scouring what you're posting to use it against you. Surveillance, kind of the same thing, except they're hiring a private investigator to follow you around and record you or take photos of you doing activities that are inconsistent with what your medical records say. If you're reporting symptoms to your doctors, you should have nothing to worry about if it's all honest and true. But sometimes people try to do things they used to do before the accident. They were a skier. They used to run a lot. They boated, fished, whatever it might be. And they want to resume trying to do these things after the accident, of course. The problem with surveillance is it's a discrete period of time. So if you do resume or attempt to resume an activity that you did before the accident and you find it more difficult, you want to make sure you report that to your doctor. At least it gives you a defense if they ever present that surveillance video. You say, yeah, of course, I've tried boating again. But your lawyer will be able to point to the medical records and show that you're not boating as often, it's now causing you harm, etc. We also have a video in depth on surveillance and how surveillance is used by insurance companies to defeat and minimize personal injury claims. I'd encourage you to take a look at that video. It goes into a lot more detail. Getting more money in your personal injury case isn't about any trick. It's really just about doing the right things to protect your rights and present your case in a way that allows you to maximize your recovery for now, but also for your future. If you have any questions, feel free to reach out to us. We'd love to hear from you. We hope you enjoyed this and found this helpful. Thank you for watching.